almost every single policy has a duty to defend. And what that means is even if somebody brings a bogus claim against you that doesn't really have any merit, they're lying through their teeth, whatever it is, your insurance policy, as long as the claim is something that is covered under the policy, the insurance company has a duty to defend you. So they're going to hire an attorney or hire a law firm that's going to come in and defend this claim, bogus or not, true or not, right?
Okay.
And I think that, so this ties into the first thing we were talking about, mainly because you want to make sure that whatever the claim is subsumed by your insurance. That's first and foremost, right? So that you can then lean on the insurance company on the duty to defend.
Okay.
And so if your policy, it should have a duty to defend, but it's important that in order for that duty to defend to kick in, the thing has to be covered under the policy.
Okay.
You see what I'm saying?
And you said should. I mean, is that yet another exclusion I should be worried about when I'm talking to, or is that's pretty much?
It's pretty much standard that there's a duty to defend.
All right. We never want to say anything is 100%, but you should have a duty to defend in there. However, you're not going to be exercising any duty to defend if you're not on a covered claim.
Right. And so what happens is you'll get a letter from an insurance company. So let's talk through the process real quick.
Okay.
Right. Somebody files either a lawsuit against you or threatens to file a lawsuit against you. And we're talking about businesses. We're not talking about car accidents. We're not talking about slip and falls.
Right.
We're not talking about personal injury type things. We're talking about, business claims, business issues.
Sure.
And so somebody threatens to file a lawsuit against you. You then would potentially reach out to your insurance company and make a claim and say, these people are threatening to file a lawsuit or these people have filed a lawsuit. And the insurance company then analyzes whether or not that claim falls under your policy.
Right.
And then if it does fall under your policy, they're supposed to assign coverage. So they're going to assign a defense. They're going to assign an attorney that'll step in and basically defend you.
Okay.
Okay. A lot of times what they'll do at that moment, even though they're going to defend, they're going to send you what's called a reservation of rights letter.
Okay.
And that reservation of rights letter says something along the lines of, if it turns out that you did this, we're covering it. But if it turns out that you did that, we're not covering it. Right?
Okay. Do I get to choose the attorney or no? What the insurance company is going to provide that? And once I assume, and this is what probably you're going to talk about, when you do that reservation of rights, you want to make sure what you're agreeing to. But I don't mean to give away the plot here.
Okay. So I'll answer both of those questions real quick and then jump back in. So number one, the reservation of rights letter, you don't agree to. That's just the insurance company's
just letting you know.
We're letting you know what the deal is.
Okay.
Right. And you could dispute that, and we'll talk about that a little bit later, but you can dispute that.
Okay.
Okay. But the other piece that you asked is a great question is, do you get to pick your own attorney? What does your policy say? Right. So some people's policy, they might pay extra to say, hey, we have these lawyers that we use for all of our business, and this is how much they charge. And if we get sued, we want these lawyers to represent us. And so that could get written into your policy. More often than not, you do not get to pick your own lawyer.
Right.
So that would be an excess amount that you pay.
Okay.
You also always have the option, and we'll get to this too, is even though they assign an attorney, you have an option to hire your own attorney at your own cost to oversee that attorney. But we'll get to that.
Okay.
Don't let me forget that either.
That's going to be important.
All right. So back to the reservation of rights letter. So
Okay.
they send you a reservation of rights letter, and it'll say, if this happened, we're covering it. If this happened, we're not covering it. And let me give you specifics. So insurance typically doesn't cover knowing purposeful conduct. So if you did something on purpose, they're not going to cover it. They don't cover fraud, for instance, right? If you defrauded somebody, your insurance is not going to cover fraud.
Sure.
It will typically cover negligence, right?
Okay.
So, oops, I did this by accident, covered. Oh my God, I did it on purpose, not covered.
Got
right?
it.
And so and when lawyers sue, they sue via shotgun approach. So they'll sue you for negligence and fraud, for instance.
See
right?
what sticks.
See what sticks, right? And so your insurance, the reservation of rights letter will say, if it turns out that you're negligent, we're going to defend you. But if it turns out that you were negligent, we're going to cover this. But if it turns out that you did this purposefully, knowingly, and willingly, and you defrauded somebody, we're not going to cover it.
Got it. And when does that get revealed? I mean,
at the end.
At the end. Okay. So if you're sitting there going like,
I don't know.
I'm doing my Mr. Burns impression. Like,
right.
Yes, Smithers, we did do this, but right. You may find out, you think you're covered, you think insurance is stepping in, and all of a sudden at the end, they're not going to cover you, which means I imagine all the coverage is gone. That attorney that they got for you, you're probably having to pay for?
They
Is that all
they
that?
will have paid for that attorney.
Okay.
Again, it might be different depending on which policy says what.
Okay.
It's not always clear, but there's so much there to unpack. So I want to come back to that question. Okay. But I just want to cover the reservation of rights piece real quick. So you get this reservation of rights letter that says if you engage in negligence, we're going to cover it. If it turns out you engage in fraud, we're not going to cover it. Right. But we're going to defend you in the meantime. Fine. For most people, for most businesses, for most issues where it's, negligence or it's a slip and fall, it's usually going to be covered.
Sure.
Right. Sometimes that reservation of rights letter won't be a reservation of rights letter. It'll be a denial letter. And it's going to say for reason A, B, C, D, this is not covered under your policy. And we're not providing you a defense and we're not covering this at all. Right. Sometimes it'll even say things that are a little bit strange. It'll say, we're going to provide you a defense here because we are supposed to cover all bogus claims, again, depending on what the policy says. But we're going to provide you a defense here. But if you're liable at the end of the day, we're not going to cover it. Right? So we're only providing a defense. We're not providing coverage. That's something else that happens, right?
Okay.
Or you get and I might have said this already, but you get the denial letter, just we're not covering anything for reason ABC.
That seems to make more sense to me than like a little bit pregnant, where we're like, we're gonna give you a lawyer, but we're not gonna cover you.
Well, we have a duty to defend, but if it turns out that you did this, you're not covered.
Got it. Okay.
Right? And so that's really the time that you want to get a lawyer involved. So as soon as you get that reservation of rights letter, if you hadn't already involved a lawyer because you got sued or whatnot, right? That's really when you want to make sure to get a lawyer involved. If you get a coverage denial letter, you want to get a lawyer involved. If you get, we'll defend, but we're not going to pay if it turns out that you did this letter, you want to get a lawyer involved, because at that point is really the best time that you have to review the policy with somebody that does this, right? And to say, wait a second, guys, you are pointing to, clause A34 subsection 5, but if you look at clause B7D subsection 8,
I see what you're doing here.
it says, it says that you do have to cover this.
Sure.
And the interesting thing is, in Pennsylvania at least, the law is if it's confusing or if there's conflicting language, tie goes to the runner, right? And you are the runner as the business owner that doesn't know anything about insurance, not the insurance company who should know better.
Sold you the policy.